Good afternoon, everybody. Yeah, welcome to today's session. We're going to give probably 30 seconds and then away we go on. I think, Lyn, this is what we call a wet fireside chat.
Yeah. I think this would put our fire out. If the rain didn't do it, the thunder would.
Yep. Okay, perhaps we could say hi to everybody. And we see that we've got a bunch of you here already. So welcome to today's session. Do feel free to type in the Q&A and type in the chat. If we know you, type and say hi. We can't see who you are yet, but let us know
I can see some familiar names. You won't need to tell your elephant jokes from Celine. They've already heard them. And your lawyer jokes, I've heard them too.
You never know if I've got new ones.
Oh, yeah, I do.
Hi, everybody. I wonder if you type in the chat here, you can see each other. All right. Oh, yes. Hi. Okay, welcome. All right. With this, ladies and gentlemen, Lyn, shall we roll off to the starts and pedal off?
Unless I can travel to India, which I can see some people from India in the chat. Let's do that.
Yeah. Okay. So as you can see, right, we are going to give you kind of the highlights of India's new Digital Personal Data Protection Act. We're going to refer to it as the DPDP for short. And as you can see that India actually recognizes privacy as a fundamental right. It came up in the Supreme Court. And there's a couple of cases where that came to be true. And then there was an earlier bill. And these earlier versions at that point in time were kind of rejected then. And then when it came up in November of last year, there was this public consultation. And finally, when it was presented in August, it was passed on 11th of August of 2023. Lyn, any comments in terms of the journey that India's law has gone through?
I think it was exhausting, at least for me. It was hard to keep up with what was going on. And even in 2019 and 2022, I'm not sure if it was a public consultation, but plenty of people piled in with comments. So I would imagine the people in India who have been working on this are very glad to have seen it passed, and they can go into the next phase now.
Yeah. Now, one of the things we don't know yet is when it will get implemented, isn't it?
Yeah, the 10 months that we've got written here was right yesterday afternoon. And then this morning there was a report that somebody in India, one of the ministers, had said that it's going to be starting in 6 months' time, but there's going to be consultation on the start, which will be after they've done the G20 meeting, which is, I think, just about to start. And they've also said that they've got everything in place to appoint the Data Protection Board, that they've got regulation, they've got rules. But then again, sometimes when they've said things in the past, it hasn't happened. So we'll have to wait and see.
Yep. So we don't know exactly when the date's going to be, and there doesn't seem to be any mentions of what we call a grace period. So some countries' laws have provided for grace periods, but there's nothing mentioned in the Act as it currently stands. So these are some things we don't know yet. Okay. And so what we're going to be looking at, is kind of give you an overview of what it is in terms of the introduction, the purposes, and then the 6 principles and rights of individuals. So just looking at how they worded the purpose of the DPDP, where it's about, the purpose is to provide for the processing of digital personal data in a manner that recognizes both the right of individuals to protect their personal data as well as the need to process personal data for lawful purposes. And then there's this third part here, and for matters connected therewith or incidental thereto. Lyn, comments?
Yeah, I'm surprised given that India is a signatory to the International Covenant on Civil and Political Rights, and therefore they've got this whole human rights structure there. I'm surprised they haven't mentioned that. And if we compare it with Singapore is very focused on reasonableness. And so we see reasonable sitting in the purpose, but we don't see the same thing in India. So I don't know if that means they're going to be unreasonable. It probably just means that they're going to be pregnant.
Yep. All right. And then if we look then, right, at what the Act itself, all right, the territorial scope of the Act, it talks about the processing of digital personal data, all right, within India, and where the personal data collected being in digital form. So I guess that's kind of in electronic form, or it is in non-digital form, and then it was digitized subsequently. Yeah. So that's within India itself. But they also talk about the digital personal data being processed outside of India if this processing is in connection with goods and services to data principles within territory of India. And data principles in this case refers actually to data subjects. Lyn?
Yeah, I think it's going to be interesting, and hopefully they'll clarify it in the rules or the implementing regulations. Non-digital form, okay. So if you collect by filling up a form today with the intention of digitizing it, okay. But what if you collect it today with no intention whatsoever, but in 5 years' time you go digital? I don't know. I mean, it seems like wording it this way is going to be a disincentive for people to go digital, and that's kind of against world trends. And I wonder if in digitised subsequently they mean by key entry, just literally typing the data into an IT system through a terminal, or if they mean by uploading PDF documents or spreadsheets, or who knows. So there's a bit to be clarified there, as well as I think the processing in connection with any activity related to offering goods or services seems to be broader than what we see in the extraterritorial provision that's similar in the GDPR.
All right. And talking about the GDPR, if we look at then, in terms of what they are saying, offering goods and services, and that would mean that anybody who is in GDPR's term targeting then, data subjects within India seems to then have to comply with the DPDP.
Yeah, I think so. But it might be more broad than that. So again, we'll see what's in the implementing regulations.
Okay. And so what's excluded then would be personal data that's processed by individual for personal domestic purposes. And then there's also this other part, personal data that's made or caused to be made publicly available by the data principal to whom such personal data relates, or by any other person who is under an obligation under any law for the time being enforced in India to make such personal data publicly available. Could you unpack this for us?
This one's really tricky. I can imagine that if I myself make a filing with ACRA or with the equivalent of ACRA in India, then it's publicly available in Singapore just as it will be publicly available in India. Making publicly available themselves tends to be, I think, if people post to Facebook or TikTok and they're not keeping their posts private. It's hard to tell.
Yeah. Okay. And so the way that the DPDPA defines personal data, right, is that it means any data about the individual who is identifiable by or in relation to such data. And so here, they went one step further to define what data means. Your representation of information, facts, concepts, opinions, instructions, and this being in a manner suitable for communication, interpretation, or processing by human beings or by automated means. Comments?
Yeah, even in the existing law, we see a distinction between data and information. So they've delved down into that in India, where we don't see the same kind of delving down in other countries. So again, we'll wait and see. The thing I find more interesting than that actually, is by using the words in relation to. We've got personal data means any data about an individual. In Singapore, it's about an individual. In some other countries, many other countries, it's relating to. And that's been quite a definitional problem in some countries, in the UK, for example. So it'll be interesting to see how India deals with that.
Okay. All right. And then when they talk about a person, right, over here, you see that it means an individual, but it also means there's a definition here for a Hindu undivided family, QF, company, firm, association of person, body of individuals, whether incorporated or not, the states, and every artificial or juridical person not falling within any of the preceding entities. And so here they have a definition of family, where you've got common ancestors, etc.
Yeah, it's an interesting one. I'm not familiar enough with India to know how that HUF thing works. The rest of this is pretty much the same as definition of person in Singapore, which is under the Interpretation Act in Singapore. But quite how you apply a whole family to the law, I really don't understand that.
All right.
Maybe in the Q&A we should be asking that question back to some of our attendees from India.
I think that's a brilliant idea. That's a really brilliant idea. Okay. And so, as you guys may be familiar, right, in typical data protection laws, they've got different roles. And so here, you do have under the law where they talk about the setting up of a data protection board of India, and that will be the authority. Yeah. They will also have what's called a data fiduciary, as well as significant data fiduciary, which in the terminology means it's their version of a data controller. Yeah. And then the same with data processor and data principal we mentioned earlier on refers to that of data subjects. Any comments about this?
Yeah, I think the significant data fiduciary is going to be interesting. It's not like it's set out in the Act if you're bigger than this or smaller than that, or if you fit into these parameters, then you're significant. Instead, they're saying we will figure out who's significant and tell them. And I suppose some data fiduciaries that are not significant today might be significant in 2 years' time. So there's additional requirements that the significant data fiduciaries have to satisfy. Surely there'll be some lead time between being told that you're a significant data fiduciary and those rules applying. Otherwise, it's not going to be very workable in practice.
Yep, definitely. Okay, so we then now move on to the various principles or obligations for the DPDPA. And at least as we read from the Act itself, there are what we call lawful processing. There's accuracy, storage limitation, notice, accountability, and part of notice, we've got this concept of consent as well, and then security. So if we kind of go down and go into a little bit of each of these principles or obligations, first of all, you've got the grounds for processing digital personal data. So that's the person. In this case, your entity, your data fiduciary, may process the personal data of a data principal only in accordance with provisions of the DPDP Act for lawful purpose, and which they refer to that meaning purposes which are not expressly forbidden by law, and for which the data principal, in other words, data subject, has given their consent. Yeah, and they've got other certain what they call certain legitimate use.
Again, a lawful purpose. I think there's so much happening in India at the moment, and it's the biggest population in the world now. There may be laws that it wouldn't be particularly appropriate to process data for, but it's not unlawful to do so. And if we think of generative AI, that's the big storm of this year. And there's been a lot of criticism in Europe of, data controllers shouldn't be scraping from websites, they shouldn't be doing this, they shouldn't be doing that. But it seems like all of those sorts of things would be perfectly okay in India, unless and until India says it's not, we forbid you by law to do that. The other thing is that these three things are separate. You don't need
to have all three at the same time.
You have just one of them. Yeah, just one of them. And there's a long list in the Act of legitimate uses. And particularly from the government's point of view, it looks like they can do pretty much anything. Because one of the paragraphs is about in the interests of national security and sovereignty, or words to that effect.
Yep.
I mean, that's understandable. India's had a lot of terrorist attacks, and it needs to protect itself. But it also brings in an area of uncertainty. If we're looking at national interest exceptions to consent in Singapore, for example, we can get a certificate from the relevant minister to see if something falls within that. But in India, it looks like it's going to be a bit surprising. I don't know. Again, the implementing rules hopefully will help.
All right. Cool. And then they've got an interesting thing whereby it talks about processing of children's data, where they talk about children being those under 18, and that the data fiduciary, all right, will get, and this one, I don't know how they may do this operationally, verifiable parental consent, and that it might need to be prescribed. That's one. The other one is they will not undertake the processing of, processing children's data if it's likely to cause detrimental effects on the well-being of the child. And thirdly, they are not going to track or do, behavior monitoring of the children or have targeted advertisement directed at children. Your thoughts?
Yeah, I hope we get a lot of clarification on this through the guidelines and rules that are published. Although on the second point, the verifiable parental consent, I did see something the other day that suggested that they may use a facility that they've got in India, which they call DigiLocker. And it seems, from what I can see from the internet, it seems to be a facility that's run by the government, where citizens can upload documents, and you kind of upload them once and for all, if you like, and you can give links to those documents to other parts of the government. So I don't know if they're going to do that. Privacy advocates are criticising that. That was the context I saw the comment in. They're saying it's too invasive. But other than that, I don't know how you can get verifiable parental consent. And we've been talking about this quite a lot lately in Singapore, because the PDPC has got a consultation going on at the moment about children's data and getting parental consent.
Yep.
I can sort of see the point of it, but it's hard to know how you can really effectively doing it, or whether people are going to have different views on whether there's any detrimental effect. I don't know, but I think it's quite the fourth point there is quite groundbreaking. Complete prohibition on tracking or behavioural monitoring. Other countries, maybe you're going to need parental consent for it, but this just says you're not doing it.
Yeah. So I can imagine that the companies that does, games for kids, they're going to have to figure out quick smart how to do this, because I'm sure those games, especially those, if you guys are here, any of these apps that has games are bound to be doing some form of tracking, whether or not you're tracking for how the game is being played. Yeah. And as an example, things like one of those Candy Crush and all that, obviously doing monitoring of how you play the game in order to, whether it's a free game, to give you advertisements, or to get you to buy tokens so that you can continue the game without waiting and things like that.
And also to track you so that you can go up the various levels of the game, and so that kids can brag to their friends, I'm a level 10. What are you? Oh, you're level 7.
Yeah.
So tracking is kind of part of the game as well. So that's a bit strange. But on the other hand, the consultation document that came out from the PDPC, they've got a concept of, a game that's, or a site that's targeted at children, but they've also got the concept of which a child might use. And teenagers 15, 16, 17, they're not just confining themselves to dolls and Dungeons and Dragons. I mean, they might well be looking at, cryptocurrency sites or anything that somebody 18 or 19 might be looking at as well. So it's very hard to know where to draw the line on any of this stuff.
And they are likely going to be on social media.
Yeah.
Okay, so now moving on then, right, to the next principle they've got, which is that of consent. They're talking about consents, of the data principle means free, specific, informational, unambiguous consent, which the data principle has given clear affirmative action. And they added, as if this is not enough, signifies agreement to the processing of their personal data for the specified purposes, which means you've got to give notice by the data fiduciary. Yeah, and that's the request for consent to be in clear, plain language, in English or any other language that's being stated, all right, in the Constitution of India, along with contact details of DPO if they need to have appointed a DPO. So your thoughts?
Again, we'll need to wait and see for the implementing regulations, but we're not seeing the nuance that we see under the GDPR of employees, for example. They'll say under the GDPR, they'll say, well, they don't really have any choice but to consent. Therefore, consent's not going to be the lawful basis of process. Here, it seems that everybody's going to be covered. I mean, time will tell. I also thought the language point's interesting because India's got, I think it's 22 official languages. Most people, I think in at least in the more developed states, most kids have been taught in school in English for 2 or 3 decades now. But still, they're very comfortable talking in their own language. If you go to Kerala, very conscious now, we've got people from India on the call. I think from Kerala, the local language is Malayalam. So if you're a business just operating in Kerala, maybe you're going to print your notice in English and in Malayalam. If you're in Tamil Nadu, presumably it's Tamil and not Malayalam. But if you're a bank, say, that's operating right across India, you're going to have to print your notices in every language.
Yep.
That's not necessarily a bad thing. I was doing some work for a client here in Singapore who was working with Huawei 2 or 3 years ago, and they were, when you first get a phone, there's some apps already pre-installed. My client was going to be one of those apps. And the Huawei phones were marketed in a lot of countries in Europe. We had to translate the privacy notice into 14 languages. Yeah. And 14 and 22, I'm not sure there's all that much difference in the extent of effort that needs to be taken. So you can do it. And we might find that a lot of organisations will at least use several languages, I suspect, even if they're fairly much restricted to one local area. It'd be interesting to see how people deal with this one.
Yeah. Now, one of the examples that they gave, I think this is the first time I'm seeing a law and act that actually gave examples and illustrations, right, for the obligations and principles. And one I thought was interesting was that if you've got a person who has gone on to download an app, and the consent was for the processing of the data for the services of the app, and the second one was for accessing the contact list, and that the person has said, yes, I've agreed to it. But here's the thing, because the contact list, the phone contact list, is not necessary for the services that the app is providing, then the consent is to be limited to the processing of the personal data only for the services that they are looking for, and not that of having consented to provide the contact list.
Yeah, which seems similar to Section 13 or 14 of the PDPA, where your consent is invalid in certain circumstances.
Yeah.
But they seem to be saying the same thing. You might get consent, but that doesn't mean to say it's going to work.
And the reason I brought it up is because I've been in a series of different classes, especially on generative AI, and we were looking at generative AI apps. And we were just going through in terms of what's the declaration by the apps. Oh, no data is being collected. But when you look at the permissions, everything, you're permitted for the app, you've given permissions for that. And so there's a big contradiction, in terms of what they are declaring versus the permissions. And therefore, if these apps are made available for folks in India to download and to use, I think they will have to look at the permissions, or they're going to be caught by the law. Yeah,
I was involved. I wasn't one of the researchers, but involved in pulling some of that information together. And certainly, some of these big apps, I'm sure, will be downloaded by people in India. I mean, why not? They're globally available. People in India aren't going to say, no, I don't want to use that one when everybody else is using it. And I got the impression from seeing some of the findings from the research and talked with the team about it, that some of those app providers were completely clueless on data protection, but they'd picked up what they thought might be the right answer, whether they were using a notice generator or what. I don't know, but they didn't seem to know what they were talking about, frankly. So there could be a lot of problems with that.
Yeah. right? So folks, if you're going to be having apps and you're going to target into India, do take note of that. Okay, moving on then to notice, which is to notify the individuals as soon as it is reasonably practical and informing her in clear and plain language containing the personal data and the purposes of the processing. Yeah. And again, all right, this is a repeat of mentioning it from the previous slide, that the notice to be in clear and plain language, English or any language specified in the 8th schedule of the Constitution of India.
This one's always difficult. I mean, for some organisations, they're going to have pretty straightforward business. Maybe it's a retailer and they've got a loyalty program.
Yeah.
But particularly for platforms and social media, they're very complicated. They're very complicated businesses by their nature, and to try and write in clear and plain language in a way that people are going to understand is a huge challenge. I mean, I look at notices all the time, and I know what to look at, and I often see notices I don't really understand what they're trying to say.
And one of the things that is mentioned is that if you are processing the data of somebody before the commencement of the act, then upon commencement of the act, the companies, right, are going to be as soon as practicable, right, for example, through email or, whichever methods that's effective, describe the personal data and describe the purposes. So that seems to be that everyone needs to be doing this the moment the law commences.
Yeah, and as individuals, they're going to be inundated with notices that they don't understand. But this particular requirement reminded me of an enforcement case in, I forget which country in Europe, where in that case they'd collected personal data from a third party and they were supposed to notify all the third parties. Well, of course, they didn't have notify all the data subjects. But of course, they didn't have any contact details for them. They'd figured out, that it was going to cost them $6 million or something to identify a certain percentage of them and to do mail-outs to them literally by snail mail. So they didn't do it. And then the regulator came along and said, well, no, that's not reasonable. That you could have done it. It's not a matter of what the cost is. You should have done it. I wonder if we're going to get the same sort of situations in India on this requirement.
That would be interesting to keep an eye out on. Okay. And then moving on to accuracy, data fiduciary needs to make reasonable efforts to ensure that the personal data is accurate, that is complete, and that is consistent. And especially that's if the personal data is likely to be used to make a decision that would affect the data principal, or it's likely to be disclosed to another data fiduciary. Your thoughts?
Yeah, it seems to make sense, actually.
Yeah.
The data fiduciaries have to take care, have to put an effort into getting data right. But again, I'm reminded one of the GDPR enforcement cases where a handful of individuals had actually given incorrect email addresses to the data controller, and they were fined because they didn't have accurate data. It's like, I don't know what they could have done other than believe the person when they said that their email was, Lyn Boxall. I mean, if your customer's given you that email and your customer said, yes, I confirm this is all accurate, what more can you do?
Yep, definitely. And if we look now at looking at the security aspects, the wordings here sounds very familiar, that the data fiduciary to implement appropriate technical and organizational measures to ensure effective adherence with the provisions of the Act and the rules that's made later on. And the data fiduciary shall protect personal data in its possession or under its control, including in respect to any processing undertaken on behalf by data processor, by taking reasonable security safeguards to prevent personal data breach.
Yeah, so for the first time we see the word reasonable used. But I find these two rules strange, or maybe I haven't read them properly or something. But the first one, to ensure, it's like a guarantee. I mean, we hear the hackers are pretty clever these days. They're working 24/7 on figuring out how to hack you. Even the specialist security firms get hacked from time to time. It's not possible, I think, to ensure. And yet, on the second paragraph, they're talking about reasonable security safeguards, which is much more what we're used to here in Singapore. You can still have a data breach in Singapore despite having put in place reasonable security safeguards.
All right. Okay. So next is then looking at storage limitation or retention limitation to ensure that unless the retention is necessary for compliance with any law, that they need to erase the personal data, right? Upon which the data principal have withdrawn their consent, or as soon as it's reasonable to assume that the purpose is no longer being served. And you've got to look at whichever is earlier.
Yeah, so I think there's going to have to be an internal process attached to withdrawal of consent. Don't have to delete the data immediately, yes or no. I mean, we often see people withdrawing their consent to marketing, and then the organisation might do the deletion, a couple of times a year or something like that. But this seems to be requiring much more than that. It seems to be requiring if a person withdraws their consent today, the data is deleted by tomorrow. That can be quite a burden on organisations. It seems a bit out of proportion to what's necessary.
I'm looking that, if they have to comply with the law, they can retain it, which in that sense kind of similar, right, to Singapore side and most other laws. This part where, the moment they've withdrawn their consents, usually even if folks have withdrawn consent, there would still be some needs to retain that data for certain purposes. So they seem to be looking at both of this and kind of asking for you, the organisation, to make a determination.
In fact, as you say that, I was just reminded of, I think there was 2 cases when the GDPR was introduced, both cases in the UK, where previous, under the Data Protection Directive or Data Protection Act in the UK, people had withdrawn their consent, data had been deleted. And then for GDPR purposes, they wrote to some of the same people again, asking them for consent. And it turned into enforcement because they shouldn't have been writing to those people because they'd already, it got terribly convoluted.
They're supposed to have not retained the data, and yet they could then ask them for consent after.
Yeah. So they got caught out, or they just made a mistake. I don't know.
Okay. All right. And then this next one then is transferring of data to outside. And it seems to suggest the central governments may restrict the transfer of personal data by a data fiduciary for processing to such country or territory outside India as may be notified. So how do you think this is going to work?
Well, the whole transfer of data out of India has been debated through the whole journey. And there's been times when it's been like, well, there's no transfer of data outside of, except, and now, but now they're turning around and they're saying, okay, you can do whatever you like, which is kind of strange in itself to me, but we'll tell you when you can't do it. So problem with a blacklist like that is political more than anything. If you suddenly put a country on your blacklist, and maybe it's, what do they call them, the rogue states like North Korea or something like that, maybe nobody particularly cares other than the North Koreans aren't going to be happy. But maybe you use it as a political punching bag. Maybe you put on countries that should be friendly where there's no reason that the data shouldn't go there, but you've got your own political reasons for doing it. So I don't know. We're seeing the same sort of approach coming up in Malaysia, whereas back in, I think, 1st of October 2020, the Malaysian government printed or published for consultation a whitelist.
Yes. And
you could send your data to all of the countries on the list, which seem to be pretty much their trading partners. And that makes sense, I guess. And then that approach was withdrawn, and they're going to, from what I've heard, they're going to switch it around. So they're going to take the same approach as in India and have a blacklist. Yeah, I don't know. It'll be interesting to see how it's done.
It sounds like a scaled down version, or as when I say, the version of data localization, except it's as and when I tell you.
Yes, yeah.
Right. And it seems to suggest that they will allow for data localization, for example, in the payments sector.
Yeah, and they've already had fights with the payments companies over that same topic. Yeah, it can be weaponized. And it also brings, I think, a lot of business uncertainty. Depending on, maybe we're going to see a publication of parameters for when they're going to do this, and that'll take away a lot of the uncertainty. But if somebody's setting up their business in a particular way and it involves sending personal data out of it, well, processing personal data in India, because that's one of the good things that India's good at, but then sending it back to their home country. And what if suddenly the home country is on the blacklist? That's a huge business risk, isn't it?
Yeah.
I don't know.
And I'm now looking at this and comparing this and, linking back to the territorial reach, and that if this organization or company is outside of India and they are targeting and they're offering goods and services to the folks in India itself, and that by that, territorial aspect means this organization has to comply with the DPDP Act. But then does it mean then the Indian government can then say to this organization, even if you are outside of India, if I tell you you're not supposed to, send the data to the country that I specify, they will have to comply?
Yeah, I think so. If you're a Singapore company, for example, and you're getting your back office processing done in India by your subsidiary in India or by a service provider in India, and then the Indian government just says, okay, all service providers or subsidiaries in India must not send data to Singapore. You're stuck, right?
Wow. Okay, well, folks, big unknown here, I guess. Okay, maybe we'll hear from the folks in the webinar in a while. Okay, so in terms of the data fiduciary accountability then, right, they will then need to be responsible for complying with the provisions of the Act, irrespective of any agreement to the contrary or the failure of the data principal to carry out the duties provided under the Act, and in respect of any processing undertaken by the fiduciary or by the data processor on its behalf. Comments?
Irrespective of any agreement to the contrary sounds odd, except the IT Act that is governing personal data at the moment says that you've got to comply with the IT Act unless you agree to the contrary. So they're closing if you know the background, if you know that that's the background, this suddenly makes sense. If you don't know, it's like, what? Any agreement to what are you thinking about? So that's a bit of a historical one. The rest,
yeah. So they are looking to plug that gap that they had.
Yeah. I mean, I think previously they'd said, well, if two entities get together and they agree something stupid, that's not our problem or our concern. Now they're saying, no. You can't agree something that's stupid. You can't agree something. You just can't agree. You've got to comply with this act.
Yep. I think that's a wise move, even though it sounds a little weird when I first saw it. Okay, personal data breach. Yeah, and they are defining personal data breach to mean any unauthorized processing of personal data, accidental disclosure, acquisition, sharing, use, alteration, etc., loss of access to the personal data, and that compromises confidentiality, integrity, availability of the data. So they are using the attributes of what we commonly call the CIA here when it comes to info security. Yeah, and in such a situation, the data fiduciary will need to notify the board, that's a data protection board, and each affected data principal, the data subjects, in a form and manner as which may be prescribed. Yeah, so here you need to both notify the board, the authority, and the data subjects.
Yeah, and you'd think that this one is certainly going to be clarified by the rules and the regulation. If we're comparing with Singapore, I mean, if it's not going to cause significant harm and it's less than 500 records, you don't report. If you have to report for everything in India, the Data Protection Board is going to get awfully tired very quickly of receiving notifications. So I think they're going to have to nuance this somewhat. And it's also unclear, like, if you've downloaded data onto a thumb drive, you're in a taxi, it slips out of your pocket and it's password protected. Well, is that something you have to report or not? I mean, the Data Protection Board is going to be working 24/7 if they're not careful. So I think they'll be careful.
Yeah, and if we just look at statistics, at least the Singapore side, they get queries up to between 3,000 to 6,000, depending on which month and which quarter and so on.
Yeah.
And the population we've got in Singapore versus the size of our regulator versus the size of the population in India versus the size of the board that they're gonna need to have. I think they're gonna need a big board.
Created a huge monster if they're not careful. And I think they'll be careful, even if on day one they're not careful, they will very quickly become careful so they can manage the process.
Yeah, correct. Now, we know in India, they already have this thing, to handle queries, to handle grievance. So in this case, they're saying that every data fiduciary will need to publish, in the manner in which that might be prescribed, the business contact info of the DPO, if applicable, or somebody who's able to answer the questions, on behalf of the data fiduciary and the data principal's questions.
Yeah, and I think this is a good and sensible thing, actually. It's a hole in some countries where you have to have a data protection officer in some instances. I mean, the GDPR is like that. But if you're dealing with a company that doesn't have to have a DPO, you can be left out in the cold. So this avoids that, and I think that's a good idea.
Yeah. And grievance, redressers. So every data fiduciary to have a procedure effective mechanism to redress grievances of data principals. In a way, it's kind of like a complaints handling mechanism. But here, this is the details, the nuance in the details. Data principal who's not satisfied with the response receives no response within 7 days, or shorter periods that might be prescribed, may register complaint with the board. So that means any sort of grievance, any sort of complaint will need to be addressed within 7 days.
Which is really short.
And it doesn't say whether it's 7 working days or 7 calendar days.
I'm just reading it as if it would be 7 working days because, 7 calendar days because it would otherwise specify.
Yeah.
But for big organizations, that's going to be challenging.
Well, we will see very interesting times ahead. Okay. So with that, ladies and gentlemen, we've kind of gone through, roughly the 6 obligations, principles. Let's now go on to talk a little bit about the rights and what they call the duties of data principals. Yeah. And so under the rights, they have rights to access. They got the rights to correction and to erasure of the personal data. They've got the rights to grievance redresser. They've got the rights to nominate. Yeah. And in this case, the nomination means in the event of death or incapacity of data principal for this person, all right, that's been nominated to exercise the rights of the data principal. Yeah. And incapacity, kind of means unsound minds or unsound incapacitated body, etc. Yeah. So any thoughts about these rights?
They're the same rights as we see in various places. They don't have all of the rights that you see under the GDPR or even under the PDPA. We don't see data portability here. We we see a right to nominate. If you don't nominate, nothing happens, or that would appear to be the case. Whereas in the PDPA, there's a default. But also as a matter of general law, there'd be a default to whoever the executor of the estate is or the administrator, I think. So, yeah, these all seem sensible, so long as we'll see how they're going to be implemented. Yeah.
Yep. And they did state that the data principal have got duties. 1, to comply with provisions of all applicable laws. 2, stated that you're not to impersonate another person, right? 3, not to suppress material information. 4, not to register a false or frivolous grievance complaint with either the fiduciary or the board, and furnish only information that's verifiably authentic. And any non-compliance can lead to a fine of 10,000 rupees.
So I looked up how much 10,000 rupees is before we came on here, and it's 160, which, if we're in Singapore, we don't particularly want to pay a fine of $164, but we're not going to go broke. We might, no, we're not going to go broke. Whereas 10,000 rupees, I think, for Indian workers is quite a lot of money.
Yeah. But looking at the various duties they are stating, sounds sensible though.
Yeah, it doesn't mean, I've had some conversations with data protection officers here where I think Suntec City and the Central Mall at 𝘱𝘓 and other malls will have a mall-wide loyalty scheme, as well as the retailers in the mall might have their own loyalty scheme. Is it really necessary to identify people? We've seen an enforcement action in Hong Kong where they said it wasn't really necessary to identify people. You didn't really care who they were. And one of the DPOs for one of the malls told me, we've stopped verifying. We don't collect NRICs anymore. We could actually see that there was no need. We only care if people shop. Yep. But you'd be amazed how many Mickey Mouses and Donald Ducks shop here now. So, would that fall foul? I don't know.
I don't know if somebody, registered themselves as a Mickey Mouse, whether that's verifiably authentic. Right.
Maybe you want a photo and see if they've got big ears.
I suppose so. Okay, so, all right, Lyn, let's stop there because that's a little frivolous now. So moving on to the more serious thing, the powers of the board, and they are to function as an independent body, digital office, and direct urgent remedial mitigation measures in the event of personal data breach. They are to investigate non-compliance. They will look at conducting inquiry, following principles of natural justice, and record reasons for their actions during the course of the inquiry. They can summon and enforce attendance of persons, examine them on oath, inspect any book, data, documents, etc. And at any stage after they received a complaint, if it's devoid of merits, they may issue a warning or impose costs on the complainants. And they may also direct parties to attend mediation, accept undertaking, or impose a fine.
Yeah, it looks like they've taken a leaf out of the book of the PDPC, actually.
I think so too. All right. And so finally, ladies and gentlemen, you are probably interested to find out what's the penalties. And so the penalties, it could go as high as 250 crore rupees. And for your reference, 250 crore rupees is about Singapore 41 or US $30 million. And so this is for significant breaches. And here is ones where you've got different types of penalties for different types of breaches.
And I wonder if they'll take the approach that the PDPC did, particularly in the early years. In the first couple of years, we didn't have any enforcements, if I recall correctly. And then they did a lot of enforcements across a lot of different industries with very small penalties and warnings. So it was very much an educational exercise. So I wonder if India will do that, or if they'll come in with all guns blazing from the outset.
Yeah. Okay, so with that, ladies and gentlemen, we have concluded our highlights. And so perhaps it's time for us to take some Q&A.
Well, I was looking at some of the comments that some people that, from their names, I'm guessing are probably in India, basically saying, relax, the rules will come out, it'll all be okay. But then, somebody else saying that we're operating in India, but with our HQs in China, and China and India don't like each other much at the moment. They're having their border skirmishes again. So what if they say we can't send data to China?
Yeah. All right.
We've lost Celine for the moment.
Sorry, ladies and gentlemen. I think Celine is encountering some technical issues. If you'll bear with us for the next couple of moments while we try to sort things out. Lyn, I think you are on your own for the time being. Celine should be back soon.
Yeah. So if anyone's got easy questions for me, we'll save the hard ones for Celine when we get her back. What am I seeing? There's quite a lot in the chat here, so it's I'm seeing China is the concern. Yes, the transfer restrictions are a blacklist rather than the whitelist approach of the GDPR. But the whitelist approach of the GDPR doesn't name specific countries other than for adequacy. Then they go through a specific procedure to decide if they're going to get adequacy. Whereas the whitelist problem, as I heard it when it came up in Malaysia, was that there wasn't any particular process behind it, and therefore it became very political. Celine, we thought the storm had got you.
I think the storm got me, but luckily, I've got my elephant and I'm here now.
Okay, I was just having a look through the questions.
Yep.
So we've got, as I said, I'm not sure when we lost you. We've got some Indian names who are telling me, calm down, it'll all be okay on the day. With some rules and a statement about the act coming into full force in 6 months. So that's consistent with what was printed in, I think it was the Business Times on Monday. Although they said as well there's going to be a consultation, but I expect the government consultations don't tend to change what's being proposed in India or in Singapore or any other country.
Yep. Now, let me take the simple question first, yeah? Somebody's asking about the CIPP Asia, which included the Indian IT Acts as part of the body of knowledge. And somebody's asking, will it now change because of the DPDPA? The short answer is no, it will not, because there's no news, at least now, as to when it's going to start. And if it starts, IPP will let us know, and they will publicly publish it as well as to when the body of knowledge will officially change. All right. So, folks, this is one of the reasons why we thought it'd be good to give you guys a heads up. So, CIPPA, the body of knowledge will not change as of now.
Yeah, and I've seen some commentators who have pretty much assumed that the security rules under the IT Act will get repealed sometime pretty soon when this new act comes in, and others are holding back from reaching that conclusion. So we don't quite know what's going to happen, whether this law is going to be on top of the existing law, replace it wholly, replace it partly. Don't know.
Okay, let's go on to the next question, shall we?
Somebody asked, how can I get a job after completing privacy certification? Yeah, I'm not sure that I can answer that one. But certainly what we're seeing in Singapore a lot more than we were seeing 2 or 3 years ago is that job specifications, advertised jobs, are more and more often including it used to be seen occasionally as sort of CIPP-A or CIPP-E or CIPM would be well regarded. Then we started seeing more where it's mandatory.
Yeah. There's a question here, when does the appointment of a DPO become mandatory? I would say when the law comes in and it's only in certain circumstances. Your thoughts, Lyn?
Yeah, that's right. I just can't remember offhand what circumstances are. I mean, I know that under the GDPR, it's all but government has to appoint. And other than that, it's if you're collecting data on a large scale or sensitive data or something like that. So I can't recall now if India is doing the same sorts of specifications. But even if, we all know, even if you don't have to appoint a DPO, organisations are going to have someone who's responsible. If nobody's responsible, it's not going to get done. They have to have somebody whose job description includes, do this, that, and the other, as required by this Act, and it's part of your KPIs.
Yeah, I know that definitely those who are considered significant data fiduciary
they will have
to appoint a DPO.
Yeah.
Okay. But the thing here is, it's that the central government will be the ones to notify if you are in the category as significant data fiduciaries.
Yeah. And as I said before, it might be that on day one you're not, and in 2 or 3 or 5 years' time you are.
Because of, what you're processing,
your business grows, you've been really successful, and now you've got additional requirements.
Yep.
I don't know.
Yep. Okay. Our next, what's the next question? Let me see. There's a question on data to be kept in digital format. Does the bill indicate explicitly that data be kept in digital formats rather than physical? Reason being, physical format poses more risk for the organization.
The bill's just not going to apply if the data's only in physical format. Or indeed, whatever digitized means, whether it means keyed in or PDF'd and scanned or whatever. Some organizations will be the same as they are in Singapore, where they have the HR records, for example, will be in the IT system, but there's also hard copy P files in the HR department. I know. Sometimes I wonder why, but it just is like that. And it seems strange that the data that's in the IT system is going to be governed by all these rules, but the data in the hard file system.
Yeah. Okay, the DPDP Act doesn't explicitly define sensitive personal data. Would the lawful basis for processing then follow regular personal data?
Yeah, in the same way that it does in Singapore, because the PDPA doesn't define sensitive personal data either. But over the last few years, the PDPC has, in its enforcement cases, said, financial data is sensitive, health data, children's data. I can't remember what else. And they've said, we want a higher degree of security from that data because it's sensitive. It's not conceptually the same as saying in some countries, including under the GDPR, such and such is sensitive. The default position is you must not process it, and here's some exceptions to the default. So it'll be like in Singapore. The same rules will apply whether or not it's sensitive. Unless we hear something to the contrary.
Correct. I find it that they actually mentioned for fiduciaries to be appointed or to be classified as significant data fiduciaries. They talked about the sensitivity of personal data process. Yeah. Okay. So we don't know the details of this, but that's at this point in time. Yeah. Next. Okay. There's a direct question here. Does the Indian DPDPA covers the government?
Yeah.
Okay. All right. And then, I don't understand this question. Any indication of parallel complementary regulation of non-digital personal data?
No.
Okay. Next one here. Yes, sorry.
And there's a question about, will the introduction of this Act affect the data protection provisions of the IT Act? And that's the one I was talking about before, where some commentators are assuming yes, and others are a bit like me, we don't know.
Yeah.
It seems to me logical that you'd replace, you would repeal whatever in the IT Act is covered by the new law, but I don't know.
Now, however, there are issues potentially, even if a law gets repealed, not everyone will know it or see it. Yeah. And we know of cases, for example, when within the IT Act itself, one of the section was made and that's 66A for those here who's done the CIPP. But there are certain states and news that people were still taken to court, taken to prison because they were deemed to have violated Section 66A, which has been deemed unconstitutional. Yeah. So do take notes and just watch the space here, I guess. Okay.
Yeah. And somebody's asked if the data fiduciary and the data processor agree amongst themselves to either exclude or limit or apportion liabilities. Can they do that? And it sounds to me like not, because there's that slide that you've got talks about you can't reach a separate agreement.
Yeah, that's contrary to the...
But from a practical point of view, I can understand why you would want to do that. Apportion liability. So hopefully that will be clarified in the rules and guidelines.
All right. Will the introduction of this law include provisions on reasonable security practices and procedures? This will be under the IT Act of RSP.
Yeah, so you've got the slide that had the familiar words on it.
That's under security, right?
Yeah. So whether that, we don't know. I mean, I can't see how those two requirements can continue next to each other, but maybe they will.
Maybe because the terminology or the phrase they use in the DPDP Act is very similar, at least in that phrase, appropriate technical and organizational safeguards. That is a phrase that came right out of the GDPR.
Yeah.
Whereas the RSPP that's been asked in this question is out from the IT Act. Would they refer to it? Yeah, not sure. Okay. Which other questions do you want to take, Lyn?
There's a question about whether the Indian Act has any major differences or unaddressed issues as compared with the Singapore PDPA. It is different. I guess because I'm so used to dealing with the PDPA, you've got your consent and your exceptions to consent. So India is much more flexible than that. Whether that's good or bad, I don't know. We don't see a data portability right in India, but then many of you will have heard me say before that data portability as a right seems to be a fashion rather than something that's particularly useful. So maybe the Indians have been very sensible in not including it. Other than that, we're really going to have to wait and see until the implementing rules and regulations come out.
Yeah. And the same person is saying then, in your opinion then, is there any specific clause the Singapore's PDPA which the Indian DPDPA should have emulated? And this is with reference to the ease of doing business post DPDPA becoming valid.
I'm actually surprised by how much of the new Act seems to have picked up words from the PDPA in Singapore, mostly because when back after the court case in August 2017 that said there's a constitutional right to privacy, they formed a committee, and there was I thought, an interesting report that was published by that committee. And the first chapter of it was the most interesting because it said there's no reason at all why Singapore should simply copy the laws from another country. There's no reason why it should copy GDPR. There's no reason why it should do this. We're going to come up with something that suits the Indian environment. So I'm not going to put myself out on a limb and say what they should or shouldn't have included compared with Singapore. Yeah.
Okay. Right then, we've got there are folks who are making comments, towards the end. They are, talking about transfer of data, and they talk about the board being set up, minor issues to be clarified, terms of use, concerns and feedback being captured, and lines of publishing. Okay, interesting. Okay, let's see. Okay, any other questions?
There's a couple of really hard ones at the end.
Yeah.
On the HR. I think, at least for me, I would have to think them through to answer them, even on the basis of the information that we have so far. But we're probably going to get more details implementing regulations. So you might need to just hold that question for a while, or panic as you may.
Yeah, we just don't know enough right now. Yeah, I agree with you, Lyn. This is a hard one.
Yeah.
Okay. Then ideas regarding types of companies that will be designated as. Well, there's significant data fiduciaries, and are we expecting the rules to provide some thresholds? Based on what we see of the Act itself, which you can actually get on the 𝘕𝗎𝘕 web, they have got a few things in terms of volume, sensitivity of data, size of the organization, that sort of thing. But they don't define, what is big volume and what's high sensitivity. So we don't know. Yeah. Okay, what else? Okay, if a customer domiciled in India comes to Singapore to open an account, does the Indian law bites? Not that we did not target India market actively.
Yeah, I mean, I don't think so any more than the Act applies if somebody happens to come in from Europe. The GDPR doesn't apply, although it's a common misconception that it does, but it doesn't.
Yeah, yeah. But it sounds like this is a bank thing. And if it's a bank thing, the question then is, does this bank also operates in India?
And does it operate in Singapore or in India, whatever way it's going to be, through a subsidiary or through a branch?
Yeah.
Because you do get the issue in Singapore. Occasionally, a European company will operate as a branch in Singapore. I've had some like that, and they have to comply with the PDPA of Singapore because they're here, they're an organisation, but they must also comply with the GDPR.
Yeah.
But if you've got the more generally occurring instance where a European company, or in this case an Indian company, sets up a subsidiary in a subsidiary in Singapore, it's going to have to comply with the PDPA, but not the Indian law as well, unless it's that extraterritorial provision. And it wouldn't usually make why would you set up if you're in India, why would you set up a subsidiary in Singapore to market goods to people in India? I mean, this doesn't make any sense. It's not likely to happen, I would think.
Yeah. Okay, so we hope that kind of helps. Then, if processing is in connection with any activity related to offering goods and services to data principals within the territory of India. So what if the Indian entity is processing digital personal data in India, but for data subjects outside India? Does the DPDPA have extraterritorial application, which means the entity having links to other countries' data subjects outside India? Okay, let's take it in parts, yeah? If you are processing personal data in India, but it's for data subjects outside India, does the DPDPA apply to this organization?
If you're a business process outsourcing company situated in India and you've been hired by a data controller from another country to do the back office service, it's going to depend on the extent to which the Indian Act applies to data processes. And it doesn't really, as I think of it. I mean, those BPOs are going to have some of their own data. They're going to have their own recruitment and HR management. But the data that they're processing on behalf of a foreign company, I don't think that falls under the extraterritorial provision.
The question looks like as if this is an Indian entity which is in India itself, and they are processing digital personal data in India. And that seems to fit within the first part of the territorial scope of the Act.
Yes.
Yeah. So in that sense, I think that part, yes. So it doesn't matter whether the data subjects are outside of India. So it's not, as in most data protection laws, it's not citizenship based. So that's one part. But the second part is, if you are outside of it, so they're kind of either borrowing the concept, from GDPR, that you are outside, you're an entity outside India, but you're processing the data principals in India. So you're offering goods and services to data principals who are within India itself. Then you may not be within the country, but you may still fall under having to comply with the DPDP. So it's kind of similar under GDPR of establishments and targeting.
Yeah.
Okay. All right. Then next we've got anyone from India who will be interested to share how this new bill affects commercial organizations in India or MNCs with back and work performing in India. I don't know. Anyone online? You could get in touch with this person here, so maybe let us know. And does this new bill apply to local government agencies in India at the same time? And I think the short answer here is yes, it does. Yeah. Okay. And I think, two final questions. Unlike the GDPR or Singapore PDPA, the DPDPA does not require a data subject to redress their grievance before the controller, before making a complaint to the jurisdictional supervisory authority or courts. How significant is that clause in terms of administrative overhead or time lags?
Say that again. I'm not seeing the question.
It's under.
I see under 6.
Okay, the DPDPA doesn't require data subject to redress.
But it does.
It does. It does require the data fiduciary to redress a data principal's grievance. Yeah. But it sounds like you're asking the questions about if the data principal is making a complaint to the board or to the courts, and it sounds like that's at least from how the Act is, it's that if you want to make a complaint with regards to personal data protection, it's to the board, not to the courts directly. Yeah. And at least from what we're reading, then the grievance is 7 days. Yeah. So if you're talking about time, it's 7 days. Right. And the final question, assuming there would be an obligation on data fiduciary to impose similar obligations on data processor to provide a level of protection similar to what's under DPDP.
Yeah. Because you're going to be responsible for your data processor.
Yeah.
So you're going to have to do that as just as a practical matter.
Yeah. Okay. So with that, ladies and gentlemen, I think we have answered all of the questions. So we hope today has been good. Jonathan, do you have any logistics and things at this point in time?
Yes, I would like to thank everybody for joining us on this very rainy Wednesday afternoon. And before everyone goes, I would just appreciate if you could actually complete our feedback and interest form. As always, we value your feedback. We're looking for ways to improve and bring you better content in the future. And also indicate, if you're interested in any of our upcoming courses, which are related to what was spoken about with today. So I am currently sending out the slider offer. Please do click on it. And that is all that you have for me. Celine, over to you.
Thank you very much, Jonathan. So folks, we will be putting in the details of what we've got into the upcoming module. That's part of the Advanced Cert in Data Protection Principles, where we'll talk about Singapore, Hong Kong, and India. So we will be updating that module so that it reflects the current DPDPA as we currently know it to be. Yeah. So if you'd like to know a little bit more details, which we don't have the time for in today's webinar, join us for that class. So look forward to seeing you all. So with that, do let us know, complete the evaluation form, let us know. Has it been helpful? And has it been insightful? Yeah. And if there's any other things you might like to know, do drop us in the evaluation form. Thank you very much, everybody, on a good rainy fireside chat. And I think at least, Lyn, the fire hasn't gone out yet. Yeah.
I hope not. I hope not.
All right. So have a great time, everybody. Enjoy the rest of your week and appreciate your feedback in the feedback form. And let us know if you're interested in any of the other things we are doing, especially Gen AI. Right, folks? Okay. Bye-bye now.
Bye-bye.